Good morning. I trust you're all well and that you can hear me clearly. We had some issues with the previous video. I hope this one works out very well. We have some guests on Zoom. Let me just put them in, allow them in. Wonderful, yes, our Zoom people are in as well. And hopefully we'll be able to do a good webinar. We had quite a few questions being posed to us previously. And I think there were quite a lot. And I've placed them on our system. And I've only chosen 6 of them. And for the rest of the week, I shall deal with the rest of them. So that's fine. If you have posed a question, you are welcome to interact with me via Zoom. There is somebody in Zoom, but that person is not planning on partaking via video. The person would like to hear via Zoom what my response to the specific question is, and I'll be happy to do so. That's not a problem. And if you look at the screen, you'll have a full view of the question that is being posed, and I shall deal with that accordingly. Nonetheless, you are welcome to join the Zoom link via visiting www.ourlawyer.co.za. And at the same time, you are welcome to ask questions via the Advocate Muhammad Abduroaf Facebook page. So I hope we'll sort that out shortly. There's some technical issue to sort out. If you cannot hear me or there's any technical issues that side, please keep me posted and let me know. Nonetheless, let us start with the first question. Okay, the first question is quite long, and obviously I will not read the entire question out for you. It's quite extensive, and the specific questioner will obviously know what the question is. But having gone through the entire question, I basically come to a point whereby I can determine what the question is, and that is, how do I get him to pay the increase for the last 2 years and also to assist me with tertiary education? Okay, so how do I deal with that specific scenario? The specific questioner says basically 2 years ago she approached a maintenance court for some type of arrear maintenance, and now she's struggling financially to maintain the minor child, and she's now at the wit's end. And she now wants to know how does she go about in claiming arrear maintenance or maintenance for the last 2 years going forward. The long and the short of the matter is, if the maintenance order does not provide for certain items of maintenance to be paid, it could be clothing, school fees, whatever it is, then should you wish to enforce something other than what's in the maintenance order, unfortunately, you would have to approach the maintenance court again for that. That is just unfortunate and something that you have to do. I cannot advise you anyway further where that is concerned. So how does she go about in claiming arrear maintenance or maintenance for the last 2 years going forward? If the maintenance long and the short of the matter, Advocate Muhammad Abduroaf should only pay for X, Y, and Z, but at the same time, there is an inflation clause in that specific order stipulating that at the anniversary of this order, the other party should pay. If you cannot hear me or there's any technical issues that based upon the consumer price index, keep it posted. Then that will obviously be of assistance. Nonetheless, let us start with the first question. Basically, it means that the first question is quite long. The order is, for example, 1,000 rand per month, which the other party must pay. Obviously, but at the same time, the entire question out for you. It's quite extensive, and the specific questioner will obviously know what the question is. But having gone through the entire question, I basically going forward come to a point whereby I can determine what the question is, and it is, how do I get him to pay the increase for the last 2 years and also to assist me with tertiary education? For the last 2 years, and the father did not pay it. The maintenance court can. Okay, so how do I deal with that? Remember, maintenance is not the specific question is the amount of money the court makes an order.
Basically, 2 years ago, she approached the maintenance
For example,
court for
if the
some
court
type of
makes an
arrears
order that the
maintenance,
father should pay
and now
$1,000
she's, you
maintenance per
know,
month.
struggling financially
But
to
last
maintain
month,
the
the
minor
child
child.
actually cost
And she's now at the
before
wit's
the child
end,
had to
and she now
school,
wants to know
or the
how does
child
she
had
go
certain
about
medical
claiming
expenditure, or something that's
arrear
happened
maintenance
with the
or
minor
maintenance for the
child
last 2 years going
expenditure
forward.
became much
The
more.
long and the short of the matter is, if the
Because
maintenance
of
order
that,
does not provide
by
for
default,
certain items
you are
of maintenance
allowed
to
to
be
approach a
paid,
maintenance court and tell the maintenance court. Maintenance court, the current order says the father must pay 1,000 per month, but last month I incurred an amount of 3,000 for the month, 3,000 for the month of May for the minor child, for example. The maintenance court can relook the entire matter and say, you know what, the maintenance order 1,000 a month continues, but for last month, sir, you have to pay an additional amount of maybe 2,000 per month, or at least half that additional amount of maintenance which the minor child has incurred. So when it comes to child maintenance, the maintenance order is not the start and the end of the responsibility of the other party. The maintenance order can change at any time. One change could be where the other party, the party that has to pay maintenance, his or her income has increased, his or her financial position has bettered, or it has decreased and it has changed and it went worse. And the same way for the primary caregiver, the person who's claiming child maintenance. That specific person can say, you know, I lost my job, I'm earning less money, therefore he or she may approach the maintenance court for an increase in maintenance and so on. So where I'm going to with this is, it does not mean that the maintenance order said X, Y, and Z, and you cannot claim for the last 2 years if you have incurred much more expenditure which the maintenance court, which the maintenance order has not taken into consideration. So I hope that answers your specific question. You mentioned a lot of information, a lot of details. Obviously, it would not make sense for me to deal with every point. I think the bottom line over here is, your question was, how do I get him to pay the increase for the last 2 years and also to assist me with the child's tertiary education? Quick answer would be, approach a maintenance court for an order that he should have contributed more for the last 2 years, and obviously you have to justify your case and you have to be successful in your case. And at the same time, if you would like him to pay for his tertiary education, and that is not stipulated in the maintenance order, of course, the maintenance court can make an order that he pays the tertiary education as well. So that's where we go where that is concerned. Okay, question 2. Let me change the view. Okay, question 2. It is a family law, but something which we do not usually deal with in our platform dealing with. We usually deal with child custody, child maintenance, relocation, guardianship issues, consent issues, and so on. But because the person posed a question, I would obviously deal with it, and I do not mind dealing with it. Basically, this person was a second wife. The husband passed away, and obviously both wives succeeded him. A lot of things happened since the death. There was things that had to be paid. The people went to the High Court and so on. But the only question I could actually see from the entire request or registration of this question was, can I send an email to the judge advising of my challenges and report the advocate work ethic? Okay, so that's basically all that I can pick up. It's a lot of jumbling of data and information. And it mentioned I went to court and this is what happened and these are the problems that happened afterwards. So obviously it makes it a bit more difficult for me because there's no specific question that I have to deal with. But I'll be able to deal with a specific question. You cannot email a judge. It doesn't make logical sense. You can email a judge certain relevant documentation. That possibly could make sense. Let's say, for example, it's COVID-19, which is and it's lockdown, and you have to send the judge a certain document that you filed previously at the court. Cannot find it, of course, and the court has to deal with the matter. You can maybe email the judge that, or email the judge a draft order, or some relevant document. You can email the judge, but you cannot email the judge data and information. The court process does not work that. The way the law works and the way the court process works is if you want to submit certain information and documentation to court, you have to do it via a legal process. For argument's sake, if you would like to divorce someone, you have to institute divorce summons against the the person, so you have to serve the divorce summons against the other party. But however, you'll first draft the documentation, you'll have it issued, have it served on other party. Internal processes will take place. For example, the other party might want to plead to it, come with a counterclaim, discovery, and so on, etc. will take place. And then ultimately the court will have to make a decision on the case after hearing both sides of the story. That's how a matter is heard in court. Judges aren't sitting there just to receive data and information from people randomly, and based upon that make decisions on matter. That doesn't work that way. You present the information via the rules of the court, the High Court rules or the Magistrates Court rules. You make an application, you serve the application on other party. Ultimately, once that has all been done, then the matter will be before a court, and the court will make a decision after hearing both sides of the story. So I hope that sorts you out where that is concerned. I really feel sorry for the problems that you are going through since the death of your husband. And I thought about it when I read through your questions quite a few times, is that it may be best for you to obtain the services of an attorney to assist you with the specific legal problems that you have. Okay, question number 3 is more of a complaint, I see. It goes as follows. Why are there still so many single moms having to fend for their kids' school and work? Don't understand that we have this alone and that we cannot yell for when our child needs us. Is there any way I and many other mothers moms can be protected without getting battered verbally by our boss or school saying we are incompetent in a nice way? That is obviously a complaint which you have against employers. I do not know if all employers are that acts that specific way. Let's say, for example, the child is ill and the mother, no one is there to care for the minor child, and unfortunately the mother has to go to work. She's a single mom, but the child is very ill. So what happens then? She takes time off work, phones the boss. Boss, sorry, I cannot go to work. My child is very ill. There's no one to look after him or her. I cannot take the minor child to daycare because he's coughing and sneezing and with COVID-19 and all those specific issues. Sorry, I got a comment over here. Okay, that was somebody from the Zoom stipulating that he appreciates the advice and he had the answer. So I think I have answered that specific question earlier on. So let's in that specific aspect. Sorry about that. I had to deal with that. So moms all find it very hard. I'm a single parent, single dad as well. You know, you work for your boss, and the boss expects you to come to work every day and to be invested in his or her company, and he pays your salary at the end of the month. But now you have family commitments. You know, the child's teacher phones you, the child is struggling in school, you have to take time off work, parent meetings and so on. So we have the challenge whereby the school gives you certain slack or certain problems or certain, lip, if I'm looking at the question, because you're not always available to come to school and, speak to the teachers regarding your child, and the employer, on the other hand, gives you the same type of slack because you're not focused, you're not committed to the work because you take a lot of time off work for your child. And obviously, either way, it's not right, it's not fair. And, the law should come to the assistance of parents from all aspects. But at the end of the day is if the school or the employer acts unreasonable, then that is obviously a complaint you can have against that specific school. So there is no specific legal question here. For example, the legal question would be if I take off work because my child is sick, of course, the labor law says, you can take certain type of emergency leave and so on. But I'm certainly know that. But I find it very disappointing that the attitudes of schools and of employers, and obviously I'm not generalizing, I do not know which school this person is referring to or which employer this person is referring to, but if this is true, obviously it's something which is concerning and something that must be done about it. Okay, that's question number 3. Let's get to question number 4. My son's father didn't attend our first hearing at the maintenance court on Thursday in Durban, but he says he was granted an audience with a magistrate in Pretoria on Friday. So we're dealing with Durban, we're dealing with Pretoria, okay? Is this normal? No one even looked at my file or let me know any of this. I filed the maintenance. Should I be consulted or informed? Okay, so here we're dealing with a scenario whereby the father told the mother something. We do not know if it's true. Maybe this went to the maintenance court in where he resides in Pretoria, I presume so, and had a chat to a magistrate there. But we all know the law. The law says a maintenance court can only a maintenance court only has jurisdiction to hear a maintenance matter or maintenance complaint if the caregiver, in our example, the mother or the child lives within the court's area of jurisdiction, or the mother works in that court's area of jurisdiction. So if the mother lives in Durban with a minor child, and the father went to Pretoria court, I think he could have had audience with the magistrate, but I doubt. Good afternoon. Welcome to our live webinar. Today's topic, urgent child contact and guardianship consent issues. Okay, that's a mouthful. Nonetheless, we'll try to unpack it, and hopefully at the end of the webinar, we'll all be much more wiser. Please feel free to share this video and interact with me via Facebook Live, or make use of those icons below. Question number 1. Or the title of the first question is, I have been in diffuse contact with my daughter. My daughter is 4 years old. I was present at the birth and paid for it, I presume. I saw her every weekend until she turned 3. Then after that, access was only when the mother allowed. The mother is an alcoholic and just wants money. What can I do to have regular contact? I also want custody in the future. Okay, so we're dealing with a lot of issues here. The parties were together, the father was at the birth, the child was born, he had contact until the last year. Since then, contact was sporadic whenever the mother says he may have contact. There could be various reasons for that, I do not know, it's not stated. But at this specific point, he wants to know what can he do to have regular contact with the minor child. So the law is quite easy. If the parties cannot agree on care and contact rights, unfortunately, the law needs to get on board. The father would have to try to resolve this matter with the mother via some type of mediation. In terms of Section 33 of the Children's Act, it says specifically, if the parties cannot agree on these specific aspects of contact, care, and so on, parental rights and responsibilities, they should try to resolve this matter out of court first with mediation and so on. So my advice to the father is clearly, firstly, try to resolve this matter with the mother out of court. Go to an organization that deals with mediation, and we can Google that. Google mediation, child custody issues, social worker. There are many organizations that can do that. I do not want to mention any names live now. That could be dealt with in a different video. And ask them, please contact the mother and ask the mother whether or not she's willing to engage in a mediation session. And ultimately, if that works, wonderful, there's no need to go to court. You could potentially go to court to make this parenting plan an order of the court, so that there can be no issues in the future. But nonetheless, that would be the first step. Try to resolve this matter out of court, or maybe possibly send an attorney's letter first. If that cannot be resolved, if you're seeing we're getting nowhere, or the mother does not want to come to the table, she does not agree upon the mediation, she ignores your attorney's letter, whatever preliminary steps you have followed, then unfortunately you would have to go to court, the High Court, the Children's Court, as the case may be, and they would obviously be called upon to assist you. Ultimately, the law is simple, very simple. It says that in all matters concerning the child's best interest is of paramount importance. So it's child-centered focus. We focus on my apologies. We focus on what is in the minor child's best interest. We do not focus on what is in the parent's best interest or what other people want. We focus on what is best for the minor child. Therefore, if it would be in the minor child's best interest for you to have contact with your minor child on a regular basis, the court would make such an order. Because when the magistrate or the judge says, I hereby order the following, he must also say, they don't usually say that, but he should also be able to support it with a phrase stipulating, I believe it would be in the minor child's best interest, what I have said. So that's very, very important. But later on in this question, you're asking the question, I would like to have custody in the future. That is possible. Custody, I presume, where the minor child will live with you primarily, and the mother would have contact maybe every second weekend, half school holidays, and so on. That is possible. And at the same breath, as I mentioned early on, if that would be in the minor child's best interest, obviously the court would make such an order. Therefore, focus on what is best for the minor child. But in order for us to determine what is in the minor child's best interest, we have to look at all factors, all variables. We have to look at the current situation, the mother looking after the minor child despite her being an alcoholic. We have to look at you as well, as a father. Can you care for the minor child? Your circumstances. Where do you stay? Where do you live? Where's the school of the minor child? All those factors has to be taken into consideration. We do not have any perfect parents. Nobody is perfect. If the father isn't perfect, if the mother isn't perfect, and the child is in danger, of course the minor child should be taken out of that situation and taken to foster care, or third parties have to look after the minor child. Obviously, we want to avoid that from happening as much as possible. Therefore, maybe get an attorney to assist you, go to the courts, and ultimately the court will have to listen to you, and they'll have to make a decision as to what is in the minor child's best interest. Usually people have issues with courts if the courts do not find in their favor. It's always one that's the winner that's happy with the court system. Unfortunately, that's how the law works. I do not call it the winners or losers. I call it an assessment as to what is in the minor child's best interest. Here you had a third party who assessed the matter, and he or she made a decision as to what is in the minor child's best interest. We have some more questions. Question number 2. I work in Canada. Do I still have guardianship rights? So remember, guardianship rights refers to the legal rights over a child. A parent can have no, or a parent has no contact rights with a minor child. He or she is not allowed to see the minor child or even speak to the minor child. No contact at all. But the parent may still have guardianship rights over the minor child, the legal rights. For argument's sake, should the minor child need to be enrolled into a school, apply for a passport, visit overseas, legal stuff. Although the parent is not allowed to see the child, that parent must still be consulted when it comes to those specific important decisions like guardianship issues, legal issues. So that's guardianship as opposed to custody, contact, access, and those things. The mother of my 7-year-old daughter and I are divorced. Okay. I have always been involved in all decisions regarding my daughter. I moved to Canada soon after the lockdown for work and will be living here for the next 3 years. The mother now does not consult with me when it comes to my daughter's schooling or anything pertaining to her. Do I have rights? Of course you have rights. You divorce a mother, and I'm certain that the court made an order that you remain a co-holder of parental rights of guardianship, care, and contact to the minor child. So that's still there. However, the difficulty we're having now is that since March or April 2020, you said soon after the lockdown, you moved to Canada. That's 2 years ago, almost 2 years ago. And the mother is the one that is caring for the minor child, looking after the minor child, dealing with the minor child's day-to-day activities, while you are in Canada in a different country. Yes, you may be paying maintenance and child support. So the mother should, in terms of the court order, consult with you when it comes to these specific important decisions. But pragmatically speaking, it's sometimes very difficult for the mother to do so because you're in a different country, and there could be challenges. If the parents have challenges, that's what I'm trying to say. Ideally, the mother should email the father and tell the father, you know, Dad, our daughter is now 7 years old, or 6 years old, or 5 years old. She will be attending school soon, primary school soon, or grade R, or whatever the case may be. These are the list of schools that are available, and this is how they work. Email to the dad will have give his opinion. He can look up the schools, he can phone them, he can contact them. They can come to an agreement, and they can sit down. But ultimately, it's very difficult for the dad to make that decision because he's not the one that will be living the choices being made. In the sense of, he cannot say the child should go to a school 20 kilometers away from the minor child's home, where the mother is the one that has to travel, deal with traffic, she has to go to work, her work is most probably in a different direction where the school is. So he's sitting from the armchair in Canada, whereby he wants to decide now where the child should go to, although it's the mother that is the one who has to deal with these specific issues of the location of the school. I'm not saying he should not be consulted. He should be consulted, but he should be reasonable as well. And the mother should be reasonable as well. Because it will be improper for the mother to say, no, the minor child should go to that specific school, and it's extremely expensive school. Close location, but the parents cannot afford it again. Alternatively, the child may, for example, be Jewish, for argument's sake, but now they want to send the minor child to a Catholic school. And the minor child is used to going to a Jewish school. I'm using some extreme examples here just to try to bring across my point. But the parents have to be reasonable and they have to be understanding to the logistics applicable, especially when it comes to one parent living overseas and another parent exercising these specific decisions that are being made. So my quick answer to you is simple. Yes, you have guardianship rights. And your guardianship rights should be obviously respected, especially when it comes to issues regarding, for argument's sake, relocation of the minor child, passport applications, purchasing of homes for the minor child, bonds, and so on. However, when it comes to these type of important decisions regarding schools, where one parent will have to deal with the brunt of all those things because you are overseas, if this matter goes to court, more than likely the court will side with the mom under these circumstances. But in principle, we shouldn't get to this point. There should never be an impasse. Dad might say, I prefer the school, and mom says, I want this school, and dad should give in. Or the mom says, you know, dad, you make a good point. I agree with you because we can't afford it, and that school might be good. There need to be this specific discussion. Because I always say, you will never find a mother and a father living in the same home together who argue over a school, taking the next person to court. They do not do that. They resolve the matter. They come to a resolution where there is an impasse. They do not take each other to court. That's where I'm going to. So it's important to look at the matter from that specific point of view. Is this matter an issue that, had the parents been living together, would they have fought on the specific issue? Dad wants school A and mom wants school B. Are they to fight over this issue, take each other to court, although they live in the same room? No, they won't do that. They would resolve this issue. So my advice to you, Dad, yes, you have obviously your guardianship parental rights. If the mother is totally being unreasonable and you feel the mother is now acting totally out of course, then of course under those circumstances you can enforce your guardianship rights and a court of law can enforce it for you. And if it is in the minor child's best interest for the court to follow your specific view on what is in the minor child's best interest, the court would make such an order. The third question goes as follows. I have two issues. One, a passport application, and the other, urgent contact. My son is 16 years old. I want him to travel with me to India to visit my family, as he never met them. The mother refuses, and he does not have a passport. What can I do? So there's two issues. Number one, if the child does not have a passport, the traveling will not take place. Number one. And number two is because it's the minor child leaving the Republic of South Africa, both parents or both guardians have to give consent for that. So that's a factual thing. The father does not have a passport for the minor child, or the minor child does not have a passport, and the father does not have the consent of the mother to travel with the minor child to India. Long story short, sir, you can try to mediate this matter, but time is running out. Alternatively, you have to approach the court, and the court will have to make that decision. And the High Court in this specific scenario, the High Court will have to look at the entire case. Your reasons for wanting to visit India, the mother's reasons for not wanting the minor child to visit India, your reasons would of course be very good reasons. I want the minor child to experience the culture, to meet his family there, and to travel. And there's an opportunity for him to now, get out of South Africa. Why not? He's lucky to go visit overseas. The mother's argument might be, no, the child is quite young. I do not know. He's stable in South Africa. He knows South Africa very well. it's dangerous for him to travel, COVID-19, all those specific things. It will affect his schooling, whatever the case may be. The father might not return, but then the Hague Convention kicks in. But nonetheless, those will be the reasons the mother will obviously present to the court, and ultimately the court will make a decision. More than likely, 9 out of 10 times, the court will make an order with a provision that the minor child should return at the end of the holiday period. And if the minor child does not return, then of course, a crime has been committed because there has been a violation of a court order, and then various other international laws and ramifications will apply. I hope that answered all your questions. Thank you very much for those questions. Have a lovely day, and I hope to see you online again soon.
Where you said what actually happens or what can be done in the situation where estrangement in terms of the kid or the child is saying, I do not want to have contact because with my parent because of A, B, C, and D. And it is basically as a result of parental alienation, because I think parental alienation is something that can happen in the beginning. And then as a natural result, what actually happens is what will happen is parental estrangement. And that is where the relationship between the father or between the parent and the child is actually just, systematically broken down. So, I mean, in that case, how is it that you go about proving that? How is it that you go about actually getting or being able to actually establish that relationship with the child again, and actually being able to build that relationship with the child again? I mean, are we talking about reunification? Is that possible in this situation? Even if, let's say, the child is against reunification, or the mother who is acting, or the parent who is acting as the voice of the child is saying that the child is against, reunification services. What do you then do in that situation?
Thank you very much for that. My apologies. I see we had some type of a technical glitch regarding the microphone earlier on. I presume you can hear me well, loud and well now. As I mentioned early on, and which you might not have heard, this is the second part of the video, or of the topic, parental alienation and the law. What can I do? We listened to a video clip of somebody that watched the video yesterday or partook and sent us a voice clip regarding that specific issue. And it's a very interesting question which has posed. What can you do? The minor child no longer wants to have contact with you, and you feel that there has been some type of, involvement or some type of undue influence on the other party. But nonetheless, the court got involved. The court now said there must be some type of contact. My view on these type of matters is straight and clear. A minor child needs to have contact. It's a requirement. It's the right of the minor child to have care and contact with the parent. It's very important. That is the foundation where I'm coming from. Unless there are specific, circumstances that will not allow for it, where it will not be in the minor child's best interest. For example, the parent is abusive, the parent assaults the minor child, and various other examples. But if there's a personality clash between the minor child and the parent, the mother or the father, that in itself is not good enough reason for the minor child not to have care and contact with that specific parent. And I say the first sole reason, let's say, for example, let's say the mother and the father live in the same home. And of course, the daughter does not get well along with the mother. Does it now mean that they should not speak to each other, that the mother should leave the premises or the child should leave the premises? No, they should figure out a way on how to deal with each other, how to live with each other. And in doing so, they will figure it out. But if we have a scenario whereby, because they cannot get along, one parent should no longer have communication with the minor child, they should not be in each other's space, they should be, separated from each other, although they live in the same home, that will not make logical sense. Therefore, when it comes to parental alienation, if it was a fruit of previous conducts of either parent, whoever the case may be, parent or the child or family members that cause this type of parental alienation, there is no reason why not to force the minor child, of course force within reason, I'm obviously trying to be reasonable here, to have contact with a minor child. We should not place to have contact with a parent. We should not place too much emphasis on the minor child, what the minor child specifically want, and etc. Because today the minor child wants something. I want to live with mom, and tomorrow the minor child said, I want to live with dad. Of course, there are various factors to consider. I mean, you might have in your scenario, in your example, in your mind while I'm speaking here, you might be envisaging, sorry, lack of my words are out today, a minor child of 5 years old or 6 years old, or your child of 12 years old or 17 years old. Each case is different. All factors are different. History is different. Past circumstances are different. So I'm being general here. I might be wrong regarding one specific example and right regarding another example. But the general answer which I will give is a minor child needs to have contact with a parent. It's very important for his or her upbringing, for his or her adult life, future relationships. When the minor child is involved with another party, like the mother was involved with the father was involved with the mother, how does the minor child deal with that? Does the minor child deal with that, for example, when the minor child has his or her own children and there's some type of conflict? What does it mean? Must he or she now alienate the minor child from the other parent as her mother has done with her? So thank you very much for that specific clip. I appreciate it very much for have spent the time giving that. And there needs to be some type of active involvement from the courts, from social workers, psychologists, where they themselves need to understand that there is this concept of parental alienation. That parental alienation is live, it happens often, and that is the cause for many care and contact disputes. If there was a principle where parents support minor children of having contact with the other parent, minor children, they encourage a minor child to love the other parent, to involve with the other parent, despite the issues which the parents have. That's very important. Despite the issues the parents have, care and contact issues will be limited drastically. Court matters will be limited drastically. So thank you very much for that. So question number 1. Is outstanding maintenance a reason to refuse contact? Due to COVID-19 and lack of work, I have been unable to pay all the maintenance agreed to with the mother. The mother now no longer allows the children to have contact with me. Is that allowed? Obviously, that is not allowed. Care and contact and child maintenance issues are separate issues. They are very important and serious issues. If you have a problem with a parent not paying child maintenance, you go to the maintenance court, lay complaint, lay criminal complaint, etc. But the court will not say because you're not paying maintenance, you're not allowed to have contact with a child. In the same breath, it does not mean that you're paying all the minor child expenditure, 100% of the minor child expenditure. Automatically, you should have 100% contact rights to the minor child. It does not work that way. The same way, if a mother pays none of the minor child expenditure because she's not working, she's unemployed, she can't afford to do so, and the father pays all the minor child expenditure because he's working and he can afford to do so, and it is in a minor child's best interest for the father to only see the minor child every second weekend, then the court will make such an order. So he pays all the minor child expenditure, but he sees the minor child most probably 10% of the time. So in this specific question, it does not mean that the father is paying the father is paying very little of the minor child expenditure, like 5% or 2% of the minor child expenditure. His contact rights should also be limited to that amount. It does not work that way. So my advice to the father, please approach the children's court sooner than later where the minor child or the mother resides and lay complaint because you'd like to have contact with the minor child. And if the mother has a problem with you not paying maintenance, let that be resolved in the maintenance court. That is in the minor child's best interest in my view. Let's move to the second question. Parenting plan only allows for supervised contact. The mother had a very good lawyer, and because of that, I was forced to agree to have supervised contact with my children. They are 3 and 4 years old. The problem is the mother is the one who supervises, and I cannot bond with the children. Is it worth fighting for unsupervised contact? Yes, it's obviously worth fighting for unsupervised contact. I, from a professional point of view, believe that the general trend should be contact should be unsupervised. Supervised contact is for those serious circumstances where the minor child, for example, is in danger of being alone with the other parent. That is one. Or the minor child is very, very young and other parent cannot care for the minor child adequately, and therefore you need somebody to supervise. Or contact never took place for many years and the minor child now needs to bond with the other parent and they need a third party in between, an uncle, an aunt, a social worker, whatever the case may be. So it is worth fighting for your right for unsupervised contact. So that is my advice to you. Having a good lawyer, yes, that helps a bit with the process. It makes the process a bit more smoother for the one party. However, the court ultimately has to decide this matter on what is in the minor child's best interest and not on who has a better lawyer. So that, I hope it assists you. Fight for your child, fight for unsupervised contact. And me personally, from a professional point of view and a personal point of view, I cannot see how a person can bond with a child if the other party that does not want you to have contact is supervising the contact. It doesn't make sense. Especially when it comes to young kids, because now a child is crying, which kids cry all the time, depending upon the age, and you need to learn to pacify the minor child. I'm certain when the mother learned to pacify the minor child was probably cried for quite a long time, half an hour, 45 minutes, before she figured it out. The same way you should be given the proper opportunity with assistance maybe or the mother to figure it out, how to pacify the child. Therefore, unsupervised contact by the other party that caused you to have supervised contact, my apologies. Supervised contact, being supervised by another party that caused you to have the supervised contact is not a good idea at all. So fight for your rights. The third question, my daughter refused to visit me at my home. I have a 17-year-old daughter who refuses to visit me at home. The mother does not get involved and says it is her choice, the daughter's choice. What options do I have? My daughter is turning 18 next month. So the first challenge I have is whatever option I give you and the daughter turns 18 next month, let's say worst case scenario, best case scenario, 30 days time, how do we deal with the matter? Because in 30 days time, the minor child would be an adult and any care and contact arrangements will be futile. It won't be of application. The minor child is now an adult and you cannot force an adult to have contact with another adult, like a parent. So what can you do now? I would most probably suggest leave things the way they are. I cannot advise you to go to court because once you go to court, you'll only appear most probably once she turns 18. Leave things the way they are and try your best to try to mend things with your daughter as best as you can. She is an adult and therefore you do not have to deal with the mother anymore. Maybe now until she turns 18 years old, you have to deal with the mother from now until then. But after that, deal with her. She's an adult and try your best to resolve matters with her. But let me be fair to this question. Let's say she had to be now 14 years old. And she says she does no longer want to have contact with her father. I would then obviously want to know what the reasons there are. Does the father have any valid reasons for saying that? Is it because he remarried, there's a new family, there's some history of abuse between him and the mother, maybe between him and the child, I cannot speculate. But what are those reasons? And despite those reasons, we need to go back to my earlier principle that contact needs to take place between parents. It's very important. As I mentioned yesterday in our webinar, maybe approach a social worker to get involved and to do an investigation, maybe have parental counsel meetings, sessions with the other parent present, with a professional person, trying to resolve the specific issue. Maybe have a session with the daughter present and the mother and father and the daughter present, and try to discuss these issues with professionals involved. If all else fails, then of course you need to approach the court and see what the court has to say as upper guardian of all minor children, because the court has a greater say over your child than you and the other parent, than the mom and the dad. That's very important to note. And if the court does apply its mind and in its wisdom and so on to your specific matter, and they come to a conclusion, this child needs to have contact with the father, which I presume they will obviously try some mechanism to make it happen, either supervised contact initially to see what are the issues, maybe with a social worker supervising it, and from there move to unsupervised contact, because the minor child needs to have contact with both parents. It's not for one parent to say, or the minor child to say, I do not want to have contact with my parents. We listen to them. We hear, why does a minor child not want to have contact with the voice of the child? It's very important. It's a constitutional, and the Child Maintenance Act specifically deals with that, the voice of the child. But we listen to the child, but we do not follow exactly what the child has to say. It's very important to know. The same way with professionals, we listen to what the professionals have to say, the social workers, psychologists, but we do not necessarily always have to follow what they have to say. We take a bit of that, bit of this. For example, if the child today says, no, I want to live with mom, because life with mom is fun, happy, easygoing, no homework, no schoolwork. I do not want to live with dad because with dad, homework gets done, there's structure, there's routine, there's a curfew, and so on. Do we just follow what the minor child has to say and say, okay, because you want to live with mom, life is good, go to mom, or the mom works whole day and there's a nanny there, and the mom lives 10 kilometers away from the school where the father lives a road away. I hope that assisted you today. Thank you very much. Apologies for the sound issue early on, and have a lovely day. See you online tomorrow.
Good morning. My name is Advocate Mohammed Abduroaf. Thank you for joining our live webinar on Facebook Live. The topic, child custody and child maintenance, whereby you can pose questions and I will try my best to answer them for you. Anything relating to child custody and child maintenance. When we speak about child custody, we're basically talking about the caring of a child, day-to-day decisions, where a child will live during the week, when he or she attends school, weekends contact by either parent, guardianship issues, for example, what school a child should go to, who should consent for that, relocation, a child moving with one parent to a different province, the application for a minor child's passport. Both parents have to consent. The same applies to relocation or a child visiting a different country. That is where both guardians have to consent, and so on. That deals with child custody. Generally, there will not be any issues regarding child custody if the parents are living in the same home and they can come to an agreement regarding all aspects of the minor child's life. But the problems usually arise when parties separate. There is no longer one home. There are now two homes, two lives, basically. The mother has her own life, the father has his own life, and the child will have to now fit into those parents' lives. He or she will have to live maybe 1 week with one parent and another week with a different parent, alternatively with the one parent during the week and every second weekend with the other parent. The reason why we propose every second weekend contact, it's not a hard and fast rule. Many parents go against it and they have their own workable parenting structure. But the reason why we propose every second weekend as opposed to every weekend is that the primary caregiver, he or she would require a weekend or every second weekend to bond with the child, to have fun with the child, to go out to the malls, to go to the beaches, and so on. That would not happen during the week, because during the week, the primary caregiver would be involved in taking the child to school, doing the homework, extramural activities, having the child sleep early, etc. And if we afford put it this way, the secondary primary caregiver or the parent that exercises contact to have contact every weekend, that basically means that the primary caregiver will not have any opportunity on having fun time bonding time with a minor child. I see a question came in. If you have any questions, feel free to pose it on the Advocate Mohammed Abduroaf Facebook page, and I shall try my best to deal with it. Let's deal with the first question. It says the following. Can you contest the family advocate report, and how do you go about doing this? Thank you for that question. Let me try to unpack that. Who is a family advocate? For those of you who do not know, the Office of the Family Advocate is a government position in terms of legislation. I am an advocate myself, but I'm not a family advocate appointed by the minister or in terms of legislation. The Office of the Family Advocate, in my view, would be the eyes and the ears of the court. They would appoint social workers to consult with the parents, to consult with the kids, and they provide recommendations to the court. So basically, you have a scenario whereby you will have your private social worker, your private psychologist, where the parents can pay for, and they will provide some type of report. They will investigate the matter, and their input is very relevant and very useful. And on the other hand, we have the Office of the Family Advocate, who is state appointed. They can do the same, maybe not on all levels, but at the end of the day, there is a family advocate, a lawyer, somebody who is admitted as an advocate, and he will ultimately oversee the process should a social worker be appointed to do an investigation and so on. But if the matter is extremely intricate and the social worker is not equipped to deal with a specific scenario, let's say we're dealing with some type of serious psychiatric issues, serious parental alienation, things that are very complicated, drug abuse, alcohol abuse, neglect, and so on, and the social worker might not be the best person to deal with this. If the Office of the Family Advocate cannot source an expert who is capable of dealing with that, then an outside person might be appointed, a childcare expert, clinical psychologist, etc. The parties may have to pay for it. It might be government appointed, I do not know. But then the family advocate himself or herself will have to look at their reports, their recommendations, and they will give their view on the issue, and that specific view will obviously also be presented to the court. So long and short, the Office of the Family Advocate is, I would say, a psychological department that deals with the child's best interest, but not a private department. It's a public department. And they are basically the ears and the mouths of the court, which I've mentioned earlier on. The ears and eyes of the court. When parties get divorced and they enter into a settlement agreement, into a consent paper, that specific consent paper and settlement agreement is usually sent to the Office of the Family Advocate to have a look at, to study it, and so on, and they will basically endorse it if they are happy with what's stated in that settlement agreement. The judge will look at it, and if there are any queries raised by the Office of the Family Advocate, the judge will obviously have to deal with it before pronouncing a decree of divorce. The Office of the Family Advocate does not deal with the propriety aspects of your relationship, property aspects. They only deal with issues concerning the child. Okay, that was the introduction on the Office of the Family Advocate. The question was, I'll repeat it one more time, can you contest the Family Advocate report, and how do you go about doing this? You are allowed to contest any report. Any professional report, you're welcome to do so. But after you have contested it, and I will deal now how you possibly could contest it, after you have contested it, the court will obviously have to make a decision. Am I, placing the same amount of weight on this report had it not been contested, or am I disregarding the contesting of it? So you should have very good reasons to why you want to contest it. One reason could be based upon the report itself, the contents of the report. If the family advocate piggybacks on someone else's recommendations, or the family advocate did not do an in-depth investigation, which he should have done. The family advocate thumb-sucked, the family advocate guessed, the family advocate relied on facts which were not factually true, allegations which were not factually true, and etc. So there could be 1,000 reasons why I would contest a family advocacy report, but each case is different. I dealt with matters in the past whereby the family advocate basically relied upon another expert in coming to his or her conclusion. The family advocate did not apply his or her own independent mind to the matter. Another example would have been whereby the family advocate's office, I'm not mentioning any cases or anybody specifically here, but there's only allegations which my clients brought up, where the family advocate's office made a few factual errors in the documentation, and my client contested it. He says, we did not say that, and because of that specific allegation which the family advocate said my client has made in his or her office, the family advocate made a certain type of a recommendation. And what sometimes happens is that the parties go for mediation session, and the family advocate presumes the matter is mediated because the parties presented themselves in that specific fashion. But later on it comes about that the parties did not intend to settle on what the family advocate presumed they wanted to settle upon. It's hard for me to comment on what happens in the family advocate's office, because those mediation sessions and those specific investigations and assessments, legal representatives do not necessarily partake in it, and they shouldn't partake in it unless it's very necessary for them to sit in it, because the family advocate will have to take out his tools and deal with the specific situation at hand. So it is possible to contest it. The end of the day is the court will have to determine whether or not your basis for contesting the family advocate's recommendation is sound, is logical, and is a basis for it. A general way of it being contested would be if there is a conflicting view on the case, where two experts recommends two different types of relief, or a way of solving the problems between the parties. So the family advocate might recommend that the father has primary care, and another expert, also jointly appointed by the parties, recommends that the mother has primary care. And the way in which they have come to that conclusion, both of them sounds logically sensible and workable, but there's a conflict. Therefore, you obviously have to now challenge it. If you are the father and one report is in favor of the other party, then you would want to challenge it and you say, no, I would like the court to follow my expert or this other expert's recommendation, and these are the reasons why. At the end of the day, evidence is presented to the court either in affidavit format or orally, depending upon what court you're appearing in, and via experts, social workers, family advocates, etc. I've dealt with a matter recently whereby the court had before it previous experts who recommended X. And a year later, the matter was back before the court, and we had different experts on board, and they recommended Y. Obviously, the court had to follow the more recent experts' reports, but it's possible that a court would be in a difficult position whereby the court will have to make a decision. What am I doing? Who do I follow? Obviously, I have to listen to the experts. I will ultimately still make my own decision because the court is not bound by the decisions of any expert. But if experts are there, they have obviously consulted with the parties. That's invaluable information. They consulted with the child. Otherwise, the court will only have before it three sets of documentation, affidavits, and the arguments of the lawyers, and the court will not have had any insight or any independent insight as to what the true facts of the matter is. So that's it. That's regarding contesting a family advocacy report. You can contest it with good reasons. You need to convince the court for the court to disregard it. And the same goes to any report from any expert, social worker, psychologist, clinical psychologist, anybody. You can contest it. I have an additional question. Thank you very much for posing it. And sorry, before I go on, the person who posed the first question, you are welcome to ask any additional questions on what I have answered. The next question goes as follows. What would the family advocate view as a reasons not to give 50-50 care and contact for kids 6 and 8? So, 50-50 contact is not something which is strange. It happens on a regular basis. And usually it would happen firstly where the parties come to that agreement. The parties have separated and they said, it makes logical sense. Let the child stay with you for 1 week and with me for 1 week, or 5 days with me and 5 days with you. Whatever makes workable sense for the parties, and they come to that type of conclusion. Then there's the other scenario whereby one party believes that shared care or 50-50 care would be in the child's best interest, and the other party believes no, it will not. Usually the party who has primary care believes it will not be in the child's best interest. Then the matter will obviously have to go to court. And how will I unpack a matter like that? I will obviously have to look at the matter holistically and determine, does it make logical sense for 50-50 care? For argument's sake, let us say the father lives 50 kilometers from the mother's home, where the child primarily resides. The child's school is 5 minutes away from the mother's home. And if they share 50-50 care, it would mean that the father would have to collect the child every afternoon, driving 50 kilometers from his workplace to the child's school, collect the child, let the child drive 50 kilometers back home, and in the next morning drive 50 kilometers back to the child's school. Let's say that 50 kilometers takes about an hour. I'm stuck in here. So in 1 week, the child will have to wake up at 6 o'clock to get to school on time. And on the other week, the child can wake up at 7 o'clock to be on school on time. So that wouldn't make sense. 50-50 would not make sense in my view if those are the facts. Alternatively, the father works or the mother works. They are at work all the time and they would not have time to attend to the child's homework, extramural activities, etc. Therefore, 50-50 would not make sense because while the child is at the primary caregiver's home, for argument's sake, the father tends to the homework, extramural, music, take the child to piano if the child is a music student, whatever the case may be. And the father does that. And the child excels very well. But then the next week comes, the child's homework isn't done. The child's extramural isn't attended to because the other parent does not have time to do that. It doesn't make logical sense for that. So the 50-50 regime is a very useful regime, and I think it's wonderful if the parties can agree to it. And they can only agree to it if the circumstances surrounding it make sense, even if the parties agree to it. And the child is being detrimentally affected by that. We will go back to the 50-kilometer example, where the father in our example lives 50 kilometers away from a child's school. The child will be prejudiced thereby. And in my view, it will be selfish for the parents to do a 50-50 regime, unless it's necessary. Don't get me wrong. I mean, some people, they require the 50-50 in order to work, in order to do things that's very important in their lives. And unfortunately, the child will just have to, tag along and deal with that. That's something else. But for one parent to be adamant, I want 50-50, I want to have the child with me every half the month or half the year. But if it means that the child should now be prejudiced by being late for school, the homework not being done, having third parties care for the child because the father is at work, and so on, then I think the parties need to relook the matter. And I would not agree, I would not advise 50-50. But if the parties have come to that conclusion, I'm not here to step on anybody's toes. If that is their family dynamics and they think that's best for their kids, then wonderful. I believe that if parents come to an agreement and it's workable for them, no agreement will be perfect. No one is perfect. No scenario is perfect. If the child becomes a B student as opposed to A student, that is where the child is. That's the child's station in life, and that those are the circumstances that the parties are living in. However, if there's a dispute and one parent believes that 50-50 will not work, and the other parent believes that 50-50 will work, and then the matter goes to court, it comes before my office, to my office for some advice, or to take the matter to court, then I will unpack the matter as I have done now. I will look at the logic of the case. Is it reasonable? Is it rational? Is it in the child's best interest? Then I will proceed on that basis. Then we take a child-centered approach. Remember, the courts, social welfare, and those organizations, they do not get on board or involved if the child is not being neglected. And the parties came to an agreement regarding how the child should be cared for. They won't get involved. They only get involved if there is neglect, abuse, and so on. So parents, please, if you are thinking about 50-50, it's a wonderful idea. I love the idea, because it does not necessarily mean that the child will not see the other parent at all during the period when he or she is not with the other parent. There is WhatsApp video, there is Zoom, there's FaceTime, there's WhatsApp calls, there's phone calls, etc. So communication can still take place. The child knows that in a week's time, I will see my other parent, but during the week, I will be busy, communicating with him in the evening. So the child might become accustomed to that, and it's workable. As long as the parents find it workable, I am happy with that. So that's our second question. I hope I answered it. If I have not answered correctly or did not deal with everything you mentioned, please feel free to comment further. While I'm waiting for any additional questions to appear, I'll deal with the issue concerning child maintenance. Now, child maintenance is an important aspect in separated parents' lives, because if child maintenance is not paid, other problems arises. Child maintenance gets paid for educational expenditure, the child's education, and with education comes a lot of other aspects, extramural, sports, etc. Child maintenance gets paid, it will get used for food. Without food, we'll all be dead. No one can live without food. And shelter, without a place to stay, without accommodation, either rental or whatever the case may be, being an apartment, a home, whatever the case may be. Without that, you will be living in the streets. That is where your money goes to. So therefore, I'm a big fighter, a very vicious fighter when it comes to child maintenance and parties not willing to adequately support their minor children. Obviously, if someone wants to pay child maintenance, he is paying child maintenance or she is paying child maintenance, and there's a dispute regarding the exact amount, no, that is fine. I mean, people are welcome to dispute. The mother wants the father to pay for the pony rides, and the father said it's not necessary, he can't afford it. Maybe he can, maybe he can't afford it. We can debate that at the hearings, and he's welcome to say what he wishes to say. But for parents to outrightly say, I do not want to pay child maintenance because the mother must pay the child maintenance, child was born out of wedlock, she tricked me, etc., that's nonsense. You have a legal obligation to feed your child, to educate your child, and if you do not do that, the law will come. So with child maintenance, there is a process of applications for child maintenance at the maintenance courts. You approach your local maintenance court if you're the primary caregiver, where you reside, or where you work. What I usually do is I advise people go to your local police station and ask them where the maintenance court is. Quickest way to find out where to go to. Sometimes you might live in one area, but your maintenance court might be somewhere else. You know what I mean? So you might live closer to one court, but because you live on the border, you might have to go to a different maintenance court a bit further away. So just find out exactly where or which maintenance court you have to approach. So there's application, there's a mediation. Let's say there is a maintenance court in place, maintenance order in place, my apologies, and you feel that the maintenance amount is unfair because you are now earning less money, or the other party is earning much more money, or the minor child cost much less than the minor child used to cost. The minor child received a bursary. The child is going to a different school. When the child was in primary school, the school fees was very expensive because it was only private schools that were available, but now the child is in a public school and the child is happy there. So things have changed. You can approach a court for a variation of the maintenance order. Please remember that. The other aspect of child maintenance could be where one party does not pay child maintenance in terms of the maintenance order, and then you may approach the maintenance court and lay a criminal complaint against the other party. So that's something which you can do. Alternatively, the maintenance court can issue a garnish order whereby the employer of the person who is not paying in terms of the maintenance order has to pay the maintenance on the employee's behalf. So that's it. Ladies and gentlemen, I hope I've been of some use for you this morning. I see no further questions. Thank you for those who have posted those questions. And thank you to all of you who have partook in this webinar. I hope you have a lovely day, and I shall see you online soon. Thank you very much.
Good evening. Thank you for joining our live webinar. And today we shall deal with various questions relating to family law that are often posed to us, and many people sometimes get confused as to how to deal with these specific issues. So I have 10 questions on general aspects of family law. As I try to answer it for you, I will obviously try to unpack it so that it will make sense to you. And if you have that specific problem or dealing with a scenario similar to that, you would be in a better position to deal with it. Nonetheless, if you have a question, a live question, please feel free to post it on the Advocate Muhammad Abduroaf Facebook page, and not on the Our Lawyer and the various other pages we have. We are streaming it live on various other platforms as well. But if you are live, feel free to pose a question and I will try my best to answer it for you. I'll keep an eye. However, if you are not interested in posing a question and just want to follow along, please feel free to do so. To begin, I have the first question, and it's from the Western Cape. It goes as follows. I only have the father of my child's ID number. I do not know where he works or lives. Can I still claim maintenance for my 5-year-old child? Very popular question that I deal with. And it is a very sad question because it basically means that there is a minor child out there who is entitled to receive child maintenance, but unfortunately, that is not the case. So that's very sad and something which I obviously hope that we can try to limit and avoid from happening as much as possible. Now, the quick answer is yes, you can and you should still proceed with the child maintenance application. In terms of the Maintenance Act and the various amendments that came afterwards, it made it possible, or it made it more possible recently, for you now to obtain the whereabouts of the other parent when it comes to claiming maintenance and at the same time when it comes to enforcing a maintenance order. Now, each maintenance court has a maintenance investigator, or they should have one, and they have resources as well. With today's modern ways of locating people, one example for argument's sake would be if you register a SIM card, you have to relocate, they want proof of address. And if you applied for a loan somewhere, of course you will, provide your most recent address. And if you work and so on, SARS, bank account, the maintenance officer, using the various resources he or she may have, will use the ID number in this specific scenario and find out the whereabouts of this person. They might do an ITC check, a credit check, and various other checks. They might go to Vodacom, MTN, Telcom, and verify whether or not there is any person who is using this specific ID number on the database, and I'm certain they will find that. Everybody has a cell phone, and in doing so, they will obtain the telephone number and they'll phone this person and say, we have a complaint for non-compliance or complaint of you not paying child maintenance or supporting a minor child. We would like to institute an inquiry. We're not saying that you should pay or shouldn't pay. That's besides the point. The inquiry should first take place. And then the court will obviously make a determination on what amount should be paid. But they will obviously follow up on that. And there are various other ways of determining where a person resides. Things are so public these days. And if you have the person's cell phone number only, you can play the reverse. You can contact Vodacom, MTN, and so on, and ask them, where is this person residing? What legal information did he provide? There are various ways. The bottom line, what I'm saying here is, you should still proceed to the local maintenance court, wherever you reside. Approach them, tell them, I have the following details. Please institute an inquiry. They will do it, and they will do whatever they can with their resources to find out where the other party is residing. So that answers that specific question, number one. Let's move to the second question from KwaZulu-Natal. The question is as follows. I want to divorce my husband, but he lives in the USA. Is it possible? Where do I start? I live in KZN. Okay, so that's a question from KZN. Now, in terms of South African law, in order for you to divorce your spouse, in simple terms, one of the spouses has to live in South Africa or within the court's jurisdiction. So if you live in Cape Town and your spouse lives overseas, and you lived in Cape Town for quite some time, and your spouse lives overseas, you can institute divorce proceedings in Cape Town court. But you cannot institute divorce proceedings in Johannesburg court because you don't live in that court's jurisdiction. So, seeing that you are living in KwaZulu-Natal, you can proceed to your local family court or to the High Court, and you can institute divorce proceedings from that specific court. So that's possible. Now, when it comes to the issue as to how do you serve the divorce papers on the other party, now there is something called the dictal citation, where you serve court processes, court documents like a summons in this case, on the other party via, or not via the sheriff of that court. The normal way of serving a summons on somebody would be to take it to the sheriff. In South Africa, the sheriff will go to the person's house or work, wherever the person is, and serve the summons on that specific person. In this specific case, unfortunately, the parties overseas will have to make use of other means. You will approach your court, or your attorney or your advocate will do so, and you will ask the court, can I serve this documentation, the summons, on the other party via email? That's one way of doing it. Or via an attorney that side, that's another way, via WhatsApp, and whatever other means there is to ensure that the other party receives the specific summons. If the court is convinced that there is no other way of serving the summons on the other party because the person is overseas. And once the court authorizes that, you follow that procedure, your attorney or somebody will email it to the other side. The court will be convinced that the other party at least received it. I think that would be important And after that has happened, you proceed with the divorce proceedings. The case continues. More than likely, the other party would get an attorney locally to defend the divorce, or they might enter into some settlement agreement, etc. So that is possible. So remember the word edictal citation. You can Google it. There should be some articles and information regarding that. The third question from the Western Cape. How do I apply for maintenance against my parents who are both unemployed? I am 21 years old and studying. My parents have assets. Very important thing to note, it does not mean someone is unemployed that you cannot claim child maintenance or support from that specific person. If that was a requirement, then I would imagine people will decide to resign from their jobs in order not to pay maintenance. I know some people do that, but we look at assets as well. Very important. The person might have investments. The person might have other means of income. It's possible. And therefore, you do not look at employment per se as a sole requirement. It is possible for somebody to own 10 houses, 10 cars, loads of investments, but not working, just sitting back and enjoying the money. I'm not saying this is the applicable in this specific case, but it is possible to proceed against somebody for maintenance if the person is unemployed, but the person has assets. And here the person says, my parents have assets. Now, interesting to note, this specific questioner is 21 years old and adult already. It is possible for you to claim maintenance from your parents even though you are an adult already. And it should happen, and it happens often where a child is 18 years old in matric or grade 11, and the child requires maintenance, although the child is an adult already. But the child is not self-supporting, the child is still busy with school, still studying, that specific child can proceed to the maintenance court. So, regarding question number 3 from the Western Cape, please approach the maintenance court, your local maintenance court, and apply for child maintenance against your parents. And they will make a determination. Maybe they should pay, maybe they should not. I do not know, but an inquiry will have to be done. So that's our third question. Okay, we're moving now back to the Eastern Cape. Question number 4. My child's father does not support my child at all. I have a job offer in Canada and want to take it. However, he will not consent to the relocation. What can I do? Yeah, this is one of those interesting ones whereby a parent might not be too much involved in a child's life, but because the parent is the biological parent, he or she might be a bit difficult, sometimes legitimately so, and other times unreasonably so. But nonetheless, in this specific scenario, the mother wants to go overseas because of a job offer. The father is not supporting the minor child at all, and the mother, I would presume, believes it would be best for the minor child to go with her. She can't leave the child behind, etc. Now, if the father, I would presume, has parental rights and responsibilities, and let's presume it does have so, because even if it does not necessarily have that, the border control and various people might say he has it, and there's a dispute, and there's an issue, and you'll have problems going forward. Because he has one version and you have another version. Unfortunately, you would have to approach court, but the court, as upper guardian of all minor children, can say, you know, father, you are being unreasonable. The minor child would have a better life in Canada. The mother is going there for work purposes. Maybe the father is unemployed. He cannot afford to maintain the minor child, and so on. And the court might make a determination, considering what is in the child's best interest, to allow you to relocate to Canada without the father's consent. It happens quite often. Each case is different, of course, but the court would have to determine what is best for the minor child under these circumstances. If it is best for the minor child to remain in South Africa, but with limited financial support, the court would, of course, say the child should remain here. But if the court believes that it would be better for the minor child to move with a parent overseas, better schooling, better education, better medical facilities, resources, and so on, the court would, of course, make such a order that the father's consent is not required. So each case is different. However, we focus on what is best for the minor child. Question number 5, we're getting somewhere. From Gauteng, my 2 nieces are living with me. So this is not a parent. Their parents neglected them since they were young. What can I do to become the legal guardian? Okay, to backtrack a few steps. Only parents have parental rights and responsibilities over minor children, not third parties. Third parties includes grandparents, aunts and uncles, and so on. However, it is possible, if it is in a minor child's best interest, for those specific persons, the third parties, to acquire parental rights and responsibilities over minor children. It is possible. The court can confer that upon upon these specific parents. Therefore, should it be in the minor child's best interest for you to become a legal guardian over the minor children, the court will make such an order. And why would you want to become a legal guardian over the minor children? Very important, number 1 is, should the minor children apply for schools, they might ask, who is the legal guardian of the minor children? Problems could arise. Should the minor children apply for a passport? Should the minor children go to a doctor, medical aid, and so on? These are serious issues that the guardian has to consent. But in my scenario, in my question, the parents have neglected the minor children. And the aunt is looking after, or the uncle, I presume it's an aunt. But this specific aunt or uncle is looking after these minor children. But these problems that may arise regarding guardianship issues. The daycare will say, ma'am, your surname is A, but these kids' surnames are B. You can't be the parent of these specific kids. Where's the birth certificate? Problems may arise. I have made many of these type of applications, and in my professional view, if the facts are there, the court would not hesitate at all to assign parental responsibilities and rights to the specific aunt or uncle over the minor children. So you'll have to go to court, and the court can give you that authority. Question number 6 from the Western Cape. I think we've moved further up a bit. Okay. There we are. Is it possible to enter into a parenting plan with the other parent when the other parent is not willing to sign? Now, something to note, a parenting plan is an agreement. So basic legal principles are an agreement is where both parties agree. 2 parties have to agree. So you can't enter into an agreement if one party is not happy with that agreement or not willing to sign. So both parties will have to agree to that. Therefore, from a legal point of view, it is not possible to enter into a parenting plan with other parties willing to agree. Now, but we need also, we have a problem here. We need to deal with the care and contact arrangements. You know, what happens to the child from Monday to Friday, from Saturday to Sunday, or from the first of the year till the end of the year. Usually a parenting plan will deal with all these specific issues: school holidays, birthdays, Father's Day, Mother's Day, the child's birthday, religious days, etc. These are important things that are dealt with in a parenting plan. But if the other parent is not willing to sign, the court can make an order. The court can make an order. You know what? I've considered everything. I've considered what the one parent has said. I've considered what the other parent has said after. I've considered what the experts have said, maybe the family advocate, maybe a social worker. And I believe this is the best way to resolve this matter. Holidays will be dealt this way. Religious days will be dealt this way. The kids will reside with the parent during these times and with the other parents during those times. So the court can make a final determination. More than likely, the court might make a final determination which is in line with the parenting plan which the other party does not want to sign. However, the court would obviously have to now determine whether or not the forced order, the forced arrangement, I would say, is in the child's best interest. So that's my answer to question number 6. And now we can go to question number 7. How do I divorce my spouse if he does not want to sign the divorce papers? Now, many people are under the false impression that in order for you to divorce your spouse, they have to sign. Now, that's not how the law works. If the other party signs the divorce papers, for example, the consent paper and the parenting plan, if there are minor children involved, the divorce can be resolved much quicker. Fast, because it's an unopposed divorce. Basically, all that happens after that is you apply for a court date, you obtain a court date, you have the family advocate endorse the consent paper, and a few weeks, 1 or 2 months, you get divorced. If, however, the other party is not willing to sign the settlement agreement which you prepared, now presume you prepared that settlement agreement, and he or she has full right to say, I'm not happy with the terms of the settlement agreement. I'm not happy with it. I do not think it's fair, just, and equitable, and therefore I am opposing it. That could be his reasons. It might be valid, it might not be valid. But nonetheless, whatever his reasons are, he's full right to oppose it, he or she. If he or she does oppose it, of course, the divorce has to go its normal course, whereby you will plead, there might be a counterclaim, etc. There will be case management proceedings that might take place, there will be a discovery that will take place, etc. And there will be a trial date in due course, in a few months' time. Could be a year, could be 2 years, could be a few months, depending upon the court and the circumstances. And then on that date, the court will listen to what the plaintiff has to say, could be the wife, could be the husband, and the defendant has to say, and maybe other experts as well. And then the court will make a final decision regarding the divorce. So the long and the short of the matter is you cannot necessarily force the other party to sign the divorce papers if they do not want to sign it. However, at the end of the day, the court would obviously have to be fair and just and apply, good reasoning as to what decision the court makes. Okay, we're coming towards the end of this questions that have been posed. I do not see any questions on the live, which is a good thing in some extent, because it means everybody watching is learning and enjoying yourself, and they're not having any questions. Question number 8. Can my son live with me even though he is 17? Can he choose? His mother does not want him to stay with me. 17 years old, you're still a minor. You do not make the decision. Parents have to make a decision for the minor child. If the child is 17 and turning 18 in a few weeks' time, I think it's basically this academic, because when he turns 18 or she turns 18, automatically they're adults and they can decide what they want to do with their lives. Of course, we expect them to make reasonable and rational decisions and not decide just to leave the house and go live with friends and throw their life away. But in a serious scenario, the child cannot necessarily decide on their own. The parents will have to decide. But what if one parent wants the minor child to live with him or her, and the minor child wants to live with him and her? Now, these are the difficult questions that comes about. Is a divorce order, is an order stipulating that the one parent is the custodian parent of the minor child, and so on. If there is no such agreement and the child has always been living with the one parent, I would advise that you resolve this matter by taking it to the court, to the children's court, or to some legal person if the parties cannot resolve it. Alternatively, take it to a social worker, and the social worker or psychologist can try to resolve this issue for you. After consulting with the minor child, looking at the parent's circumstances, what is best for the minor child under these circumstances. Because 17 years old could be an age where the child could be in matric or grade 11, an important age in the child's life. And we do not necessarily want to disrupt the child's routine, etc. Just because, for argument's sake, the other parent now has a swimming pool, and now the child wants to go live there, or the other parent bought a house, and things will be fun and games on that side. So the reasons why the child wants to also move to another parent are very important. So the long and the short of the matter is the child cannot decide, the parents will have to decide. If the parents cannot come to an agreement, they ultimately will have to go to the court to resolve the issue. Question number 9. What amount of maintenance should one pay for a 17-year-old child? Now, it's very important to note the law does not stipulate any amount of child maintenance for any specific child or age. In the sense of one child may have certain expenditure, schools might be a bit more expensive in a different province, extramural standard of living, and so on, where a different child might have a more modest type of lifestyle. And that's normal and that's very good for that specific family. So if I say, for argument's sake, a child of 15 years old costs child maintenance costs, for argument's sake, 5,000 per month, where another child in a different province, a different area, different family background, father might be a minister, mother might be a medical surgeon, whatever the case may be, for him, 5,000 will be too little. Maybe 50, 20, 30,000 will be more reasonable for that specific child. So there is no amount of maintenance specific to a specific child. That doesn't work that way. However, what you do is you look at the parent's income, the child's needs, child expenditure, the standard of living, and so on. And then based upon that, you come to a determination what to be a fair amount of maintenance to pay or for a parent to pay. I hope that answers your question where that is concerned. And now we are on the last question, question number 10. How 10. Why do I need the consent of the other parent to change my child's surname to mine? Okay, so this is now obviously a difficult one to answer because I do not know, are we dealing with the mother or the father? But the long and the short of the matter is a child's surname is very important towards child. The child is identified by that surname, his friends knows his surname as being X, Y, and Z. And you cannot, as a parent, just go and say, I would like to change the child's surname to my surname because I would prefer it that way, despite the child having the other parent's surname for the last 15 years of the child's life. Both parents need to consent to it. If the parents cannot come to an agreement regarding the surname change, of course, the matter will have to go to court, and the court will have to determine what is in a minor child's best interest. So the bottom line is, for a parent to decide to change a child's surname to a different surname, despite the child having a surname all his life or her life, would not be the child's best interest. Thank you very much for partaking. For all the people that are viewing this webinar live, it's much appreciated. And I hope that you had a good learn from these 10 questions, and I hope to see you online again soon. Thank you very much.
Good afternoon. We'll start the video soon. We are just waiting for a few more participants to join. I trust you all can hear me. I think we can begin. Good afternoon. My name is Mohammed Abduroaf. I'm a practicing advocate in Cape Town. I'm connected to a company called Our Lawyer Pty Limited. And Our Lawyer Pty Limited has a Facebook page. And on that page, we try to promote various legal topics so that we can inform the public about various issues that you might face. And hopefully, if you find this video useful or beneficial, we ask if you can kindly share it. This video is streaming live on Facebook on various platforms. So if you do not want your face to appear in this video, please mute your video. Later on in this video, we might have one or two people speaking, and you're welcome to pose a question if you wish to do so towards the end of the video. Firstly, this is a free webinar, so if you have posted questions previously, sorry, for the last day or two, I have recorded those questions in a spreadsheet, and I've placed it into a PDF document. So those questions I'll deal with. If at any point you wish to pose a question live, you're welcome to do so. I think we can begin. The first thing I'll do is I will place on the screen the questions that were posed. Those are the questions. I hope you can see it. Those people watching this video via the Facebook pages, the live stream, unfortunately you won't be able to see the screen which I can see and the participants can see, but hopefully you can listen and be able to follow. Firstly, thank you for partaking, all those who are here today, and I hope you will benefit from this video. So today's topic basically deals with the issue concerning child custody and parenting plans. It's a very interesting topic, and I would say also a serious topic, because when it comes to the issue of parenting plans, it means that the parties cannot come to some type of an agreement regarding their contact rights, their care rights, etc. towards their minor child. I won't go into much detail of the law because many people do not understand the law, and that's why they actually watch these videos. I believe many legal practitioners, they focus too much on mentioning the Children's Act, mentioning the Constitution, mentioning various pieces of legislation, which nobody really understands, or those who do understand it are basically lawyers. So I'll try to follow a lay person's approach and try to advise you accordingly. So let's begin. What is a parenting plan? So a parenting plan is an agreement which you have with a co-holder of parental rights and responsibilities, basically with the other parent, whereby you guys come to an agreement regarding your contact rights, your maintenance obligations, guardianship issues, basically when you can see the child, when you can't see the child, matters concerning school holidays, extramural activities, etc. So it's a plan which you have agreed to with the other parent in how you two are going to be the best possible parents for the child. It's very important to note that. It's not a document which is templated in the sense of one document fits all. It doesn't work that way. You and your child and the other parent are best fitted to decide how you are going to parent your child. All kids are different, ages, preferences, needs, etc. Therefore, we can't say that one parenting plan fits every single parent or every single family situation. For argument's sake, a child might be 17 years old. His or her needs will be different than a child of 15 years old because the 18-year-old child is in matric. And at the same time, parents might live in different, suburbs. One parent might live in Cape Town, CBD. The other parent might live in, for argument's sake, Belleville, or in different provinces as well. So there's no one parenting plan fits all. That isn't how it works. Basically, what you are saying over here is, let us look at the situation. Let us look at your specific family and what's the best way to, to plan ahead with regard to caring for the child. So the quick example which I like doing is, I would say, if a client comes to me and say, look, let's work from Monday till Sunday. What do you suggest happens on the Monday? Does the child wake up at your place? Or does the child wake up at the other party's place? Who takes the child to school? Do you take the child to school? Or does the other party take the child to school? Who collects the child from school? And who does the child sleep the Pacific evening? So those are the questions you have to ask. So you go up until the Sunday. Then we go into the issue concerning birthdays. What happens on the child's birthday? Does the mother have the child during the morning? Does the father have the child during the morning? Or what if the birthday falls on a public holiday on a weekend? What happens then? Then we're dealing with Father's Day, Mother's Day, what else is there? Religious days, Christmas, Eid, and various other religious holidays which various denominations will have. Then we deal with issue concerning school holidays. Does this child stay with you for the first half, with the other parent for the second half? Does the child continue, with 1 day on, 1 day off? Is it 1 week on, 1 week off? No, that has to be discussed. I'm just being general here. So we come to a scenario whereby we plan a parenting document for an entire year. We might change it as we go along. Maybe when the child is 6 years old, we'll have a certain type of parenting plan, not allowing, for example, sleepovers during the week. Or alternatively, when the child gets older, maybe 10, 12 years old, then we might start implementing a certain type of, midweek overnight contact, if it's in the child's best interest and it's possible and it's workable, etc. So remember, if you ask me, how should a parenting plan be drafted or what should it entail? Let's start off on the 1st of January 2021 and let's move on to the end of the year or the 1st of January 2022. And based upon that, we can work something out. Obviously, a parenting plan will have various, falling on clauses. For argument's sake, if the parents cannot follow the parenting plan for a specific period of time. A typical example would be COVID-19 with a lockdown. Kids were at home for many months, where previous years kids were at home only for a period of a month, and we shared the school holidays. So those are the complicated issues that might arise, or one parent will have to go away for work purposes, or one parent might remarry and go on with his or her life, and there will be like a change of a abductness in the specific parenting plan. But be that as it may, there needs to be some type of flexibility. So you will have in maybe a facilitation clause in there stipulating if the parties cannot agree upon a certain issue concerning parental rights and responsibilities, for example, a Pacific school holiday, an important event like another parent getting married, because one parent might say, no, that's my weekend. The child can't be in your wedding because it's my weekend. I think that's being a bit unreasonable. But if that is the case, there should be a clause in there to stop the parties from, firstly, arguing these specific issues, and secondly, trying to resolve these issues without going to court. So that's where the parenting plan has to deal with those issues. So on the whole, a properly well-drafted parenting plan would be a document, I would say, of no less than maybe 10 pages, dealing with those specific scenarios, especially the issue concerning dispute resolution, because you cannot go to court every single week or month because there's a problem. And things happens, and it always happens. And as I said earlier on, the reason why we have a parenting plan is because parents cannot come to an agreement regarding these specific issues. Then later on, you'll see a few questions being posed where the specific participant would ask a question regarding how can she get or he get sole custody over the child. Now, custody, guardianship rights, care and contact, those are very nicely stipulated on paper. You go to a lawyer, you draft something for you, you go to court, the court drafts something, etc. But these are real people, real human beings, children's lives. So you can't necessarily, deal with these things only on paper. We need the parents to be responsible, to be reasonable, because the law cannot always come to your assistance in resolving these issues. So if the mother is adamant, she believes she controls the child, she believes she owns the child, she believes that the father's rights to the child will be only limited as to what she can dictate to the father because she gave birth to the child, and the father was most probably not involved in the child's life for a lot of time. Maybe because that was by your choice, or maybe because the mother didn't allow it, as the case may be. I'm just dealing with the scenarios which comes to my desk on a regular basis. And at the same time with the father as well. Many fathers out there also, they have not done their responsibilities, towards their child. But that's the past, and let's move forward. That's always my motto in dealing with these type of matters. People come to my office regularly and they like to badmouth and talk bad about the other parent from 10 years ago until now, which is fine. You're welcome to do that. You're paying for the time, but it won't assist us going forward because the court is concerned what's best for the child, and what's best for the child is going forward, not going in the past. So a scenario that applied where the child was 1 year old and now the child is 10 years old, things have changed. Parties have remarried. I do not necessarily want to listen to what happened 10 years ago. I want to hear what happened just prior to you coming to my office, because that is most probably relevant. So, if a party asks me, I would like to have custody over the child because he or she has been caring for the child for the last 10 years, the other party only sees the child once every 6 months, once a year, and now he or she wants sole custody for the child. I understand what the person wants, but maybe the term used is incorrect. You are already exercising basically sole custody over the child because the other parent is not really partaking in the child's life. So you're basically the sole custodian parent of the child. However, what you are maybe referring to is the issue concerning guardianship rights. Because whenever you go to the school or you go to the doctor or you fill in a document, he keeps on asking you, where's the other guardian? Where's the other parent? Are you a sole guardian, etc.? So matters concerning, for example, the application for a passport, for the relocation of the child, some important operations, etc., leaving the country, those specific situations, you require the consent of both guardians for the child. I'll deal with the issue concerning guardianship shortly. So you might not say, maybe your question should be reposed. You should ask me, how can I get sole custody for the child for the sole reason that the other parent is not available, is not much involved in the child's life, but every time I need to do something legally, for example, enrolling the child to a school, going to the doctor for certain procedures, medical aid, passport, going on holidays, I require this consent of this other person that does not care about the child, who is not involved in the child's life at all. Under those circumstances, your application would not necessarily be for sole custody because you're already exercising it. Your application would be for sole guardianship, whereby you approach the court and mention to the court, I'm having this problem all the time. I have to always confirm with this person that's not involved in the child's life. Please give me the authority to make sole decisions regarding guardianship aspects. So that's where we're going towards. Now, does it mean that you are the parent of the child? You are the father of the child? automatically it means that you should be consulted all the time? Does it mean that? Does it mean that automatically you have a say in the child's life at every specific point in time because you are the father of the child? Because you're the father of the child, you were involved in the child's life for the first day, but then you went missing, or you were never involved in the child's life, and now you come back into the picture 5 years later, and now you want to come and say, I would like to enforce my rights as the father of the child. The law is very concerning about the child. So it does not mean that you are the father of the child, automatically you have certain rights to the child. It doesn't mean that. If you were married to the child's mother, automatically you have those specific rights. But if you were not married to the child's mother, what happens then? Then you can acquire these specific rights of parental rights and responsibilities over the child, meaning contact rights, care, guardianship rights, etc. And how do you do that? So if you were involved in the child's life since birth, you pay child maintenance, you partook in the child's life, etc., automatically, by default, in terms of the Children's Act, you automatically have parental rights and responsibilities towards the child, meaning you're in the same position as if you were married to the mother of the child, or you divorce the mother of the child. But if you were never involved in the child's life, and all of a sudden, now you're back in the picture and you want to have a say in the child's life, no. You have to acquire those rights. You need to start getting involved in the child's life, pay child maintenance, to have contact rights with the child. If the mother refuses your contact rights, for good reason or bad reason, we advise you to approach the court to enforce your rights. So I think you basically understand where I'm going to here. I'm not mentioning law and all those things. The law is there to guide us, to put us in a proper path. If you're getting divorced, you don't go to the criminal court. And if you committed a crime, you don't go to the, to the tax court unless it's a tax crime. You go to the divorce court or you go to the high court. At the same time, if you're involved in a motor vehicle accident and want to claim money, you're not going to the divorce court, you're going to the civil courts. So that's where I'm going to with a specific topic. So let's move on to the questions that were posed, and hopefully we can get some answers regarding that. So thank you for those who have sent questions when you registered for this webinar. On this point, if you have an organization, a group of people that want to specifically have a webinar to discuss certain family law issues, you can speak to our lawyer and we can arrange it at no fee, of course. It's our way of giving back and educating people. But you're welcome to send us an email and just, motivating it, so we can have a group session, private group session via Zoom, and we can try to, empower and educate people in that specific manner. So the first question which we got, the person that registered first on our online platform was, what can you do if the co-parent won't compromise and a parenting plan can't be finalized? What if high court is not an option due to cost? So this is where I'm going to with a parenting plan. Nobody has an obligation to sign a parenting plan. Let's say, for argument's sake, the father wants to have custody over the child and sole guardianship rights over the child. Meaning he wants the child to stay with him and he wants to have the final say of the child. And he wants a mother to agree upon that in a parenting plan. Clearly the mother won't agree to it because she believes that she must have primary care or, sole guardianship rights or custody over the child, as the case may be. So there's a dispute. The parties can obviously go to a social worker, maybe the family advocate's office might get involved, see a psychologist, psychiatrist, an attorney, advocate as well, to assist him in entering into a parenting plan. But if the parties are loggerheads, where the mother wants the child to stay with her during the week and the father wants the child to stay with him during the week, a parenting plan cannot be entered into. I can't see the possibility thereof. Under those circumstances, unfortunately, you'll have to proceed with the matter in court. You will have to have the judge hear the father, hear the mother, and the court will have to make a decision as to what is best for the child. You cannot force somebody to enter into a parenting plan. I think that will be irresponsible, and I don't think it will help anyone. We won't get far with that specific matter. If you force somebody to enter the parenting plan, more than likely that person will come back to us or to the court a few weeks later and saying, sorry, it's not working out. I was forced to enter into this parenting plan. Now I would like to, fight for what I believe I'm entitled to or what is in the child's best interest. So this is a warning to everybody. Don't enter into a parenting plan unless you believe that you can live up to the parenting plan. If you cannot, take the matter to court and let the court decide. Then the person asks, what if High Court is not an option due to cost? There's a children's court. High Court is obviously cost because you get attorneys and advocates on board. If you yourself can do the matter alone in the High Court, then there is no fees applicable. The court doesn't charge you anything. However, there is a children's court and they'll be able to assist you as well. The second question. You can read the question, but it says basically, father of 3 and I have not seen my children since she left. My ex left, leaving the kids just before Christmas, returning after 8 months. Have been to family court and have not got anywhere, even though the family advocate ordered my ex to. That's why we ordered the ex to let him have contact. My ex-wife refuses and she says I must pay, and even then she still did not permit, I presume, for him to have contact. Court system, I have not gotten anywhere today, and 2 years, and have not contact at all. What should a father do? My advice to you is simple: go back to the children's court. I get this queries many times where people, they go to the children's court or to court and they don't get specific results. Then they get lawyers on board and then we get them some type of results. Not because we are lawyers, but because we were persistent in the children's court. The courts don't necessarily treat you better because you have a lawyer on board or because you are a lawyer. We many times have to stand in the same queues, still wait our turn. So the specific person, you were at court, the options of course are to appeal and take it on a review, but I don't think the court made any decision. Go back to court, make some noise. If they do not listen to you, go on the higher level, speak to the court managers, speak to the senior magistrate, etc., and let your matter be heard. The third question. As a primary caregiver, I have my 7-year-old child during the week to establish a routine and structure, in particular schooling, from Monday to Friday, and share the weekend with his father. The father recently got married, requesting time during the week, and it's not convenient over the weekend anymore to spend time with the child. Also, his spouse has a child who goes to the father over the weekends. Do I have the right to contest the request on the basis to keep schooling structure, as schooling was never priority for my ex? I'm just mentioning that these questions are basically cut and paste from the registration form. So I don't spend time, rehashing it because I think it loses effect. And then it's not my, then it's my version of the question, not the participant's version. So regarding refusing or opposing the child staying with the father during the week, can the mother do that for schooling purposes? It's a very difficult question to answer because is it her job to solely make decisions regarding what's best for the child? Because the father is also involved there. Would it be that detrimental for the child to go to the father during the week to have contact with the father? My view on the matter is the parties need to sit down. At the end of the day, the child needs to have both parents in the child's life. If the father wants to have contact with the child during the week and schooling is an issue, they must work around that. They must try to make it workable so that the child's school is not being suffering or, for lack of a better word, neglected. So if the mother is concerned about that, she has also at the back of her mind also remember that if she limits the child contact to the father and the father only sees the child now for 8 days per month, sorry, not 8 days per month, 5 days per month, meaning every second weekend, the child could in another way also be traumatized or lose out specific contact with the father that he could have had. My advice for the specific mother is sit down with the father, try to work something out. I am a full supporter of parents sharing the child as much as possible. If we have the father and is willing to have contact with the child during the week, why not? Let's make it happen. But obviously, if it's not in the child's best interest and it's not workable and the child's schooling will suffer, then it's not a good idea. But it's not for the mother specifically to decide that in isolation or the father. they need to sit down. If the mother believes it's not in the child's best interest, that is fine and good. Then my advice to the father is take this matter to the children's court. Let a third party, either the children's court or a social worker that gets appointed, let them advise you what's best for the child after they have listened to both sides of the story. I am very opposed to one parent making sole decisions regarding a child if they have not tried firstly to resolve this matter by discussion with the other parent. This specific scenario is very important to note that had there been a parenting plan in place, they could have gone to a facilitator and the facilitator could have resolved the specific issue. But unfortunately, there is not one, and that's basically the purpose of having a parenting plan, to avoid these problems from happening in the future. So let's move on. Sorry, I'm done with that. Okay, let's go further. Can a parenting plan be drafted by an individual who is not a South African and their work permit is still pending? I don't believe that the specific parenting plan is dependent upon who drafts it. The law does mention who can draft it. Obviously, lawyers can do it, social workers, family advocates office, etc. But if you are a foreign person without a work permit, I don't think that will invalidate the parenting plan itself. If the parties follow proper procedures, etc., and it's signed and they're happy with it, and the family advocate office is happy with it, I can't see any problems happening there. But that might be a labor issue. The question is, can a person charge for work in South Africa if he doesn't have a permit to work? So the next question is two-pronged. The first one is, can a father take a child from the mother in SA if the father is not a South African citizen? Yes, it's possible. You do not have to be a citizen of South Africa to have custody or guardianship rights over the child. You are the father of the child. You have rights for the child. Obviously, it must be the child's best interest. So, depends on the facts of the matter, but it is possible. The second question is it illegal to leave your child at home alone in South Africa when you have no means or income to send the child to aftercare? I cannot answer that question. I think it's not in the child's best interest for the child to be alone at home, depending on the child's age, etc. That question would best be posed to a social worker. Obviously, you want the child's best interest to be upheld. And if the mother must go to work and she must be employed and she does not have money for aftercare, that's a very difficult situation. But unfortunately, I wouldn't be able to answer that question from a legal point of view. I would advise a specific person specifically to speak to a social worker for advice on that specific topic. And hopefully they will give you some type of alternative advice. But my quick advice is, please, your child's best interest is of paramount importance, and you wouldn't want to put your child in any possible danger. The next question. So my 4-year-old daughter at the time was living with her father, and she had a speech problem, and he refused to take her for therapy. Long story short, I took him to the children's court to get primary care. I was awarded primary care, and he got visitation rights. And we were instructed to do a parenting plan through my attorney, which he refused to do. He now no longer visits his daughter since the order was in place. He doesn't phone or anything. It's been 11 months since he's seen or even called his daughter. He also does not pay maintenance. I tried to get a passport for holiday for her, and he is just ignoring my emails. I need his consent to do play therapy, and he is not receptive. How do I get his parental rights terminated, as he clearly does not care for his daughter? And she misses him, and I've begged him to call her. I pleaded with his family. We have a court order in place saying he needs to see his child, but doesn't. I can't do a lot of things like go to holiday, etc. Lost out on my job opportunities overseas because I can't get a passport for my daughter. So that is a scenario which we regularly get. It's not something which I think I dealt with something like that maybe like 10 times already, taking it to court level. Here we have a situation whereby the parties went to court. The father did not want to partake in a parenting plan situation, which he has full right to do. The court made an order, gave the child to the mother to have primary care. Obviously, they still have co-custody rights. Now the father is not involved in the child's life. He doesn't pay child maintenance, and he doesn't, visit the child. etc. The mother has a problem. The problem she has is, yes, the father is not involved in the child's life, but she wants to further her life. She wants to go overseas and work overseas. She would like to go on holiday overseas. She requires his consent now and again, but she can't get hold of him or he doesn't give the consent. This is a typical example whereby the specific parent may wish to apply to court for sole guardianship rights over the child. I wouldn't necessarily say terminate his rights of parental rights and responsibilities of care and contact, because he might come back tomorrow, the child wants to see him, and if he does change tomorrow, we can still, have contact with the child, and I'm certain the mother will be happy with that, and the child will be happy with that. But looking at the situation here, I would actually advise the mother to approach the court and ask the court that she can have sole guardianship rights over the child. So when it comes to issues concerning consent issues, traveling overseas, etc., and she needs to motivate it. She must motivate it in the sense of, I've contacted this father many times and he doesn't want to give consent. What can I do? The court might be a bit loath in giving a blanket right of guardianship, whereby the mother can at any point just leave the country without consenting with the father, without consulting with the father. But if she can convince the court, saying that this man is nowhere to be found, I can't get hold of him, he doesn't want to get hold of, and should I every 6 months or every year go to the High Court or any court to get consent to visit overseas and cost me X amount of thousands of rands, which is obviously a waste of money? Under those circumstances, she might be able to convince the court that that the court can terminate his guardianship rights over the child. The same would apply to schools, etc., medical procedures, and so on. Let's go to the next question. At what age can a child sleep over, and should adequate accommodation be available if the child sleeps over, such as a bed or bedroom? So there is no specific age. A child can sleep over at the age of, maybe 1 or 2. Obviously a little infant child, you have to consider the needs of a little baby. But my scenario I always apply is, if you and the parent or mother and the father were still living together happily in a relationship, and tomorrow the father most probably has to overnight by his sister or brother, for whatever reasons, maybe for something, and you most probably say, no, it's fine, my 2-year-old child can go and overnight with the father there. If that situation applies, and you're happy with that while you are together with him, why should the situation be different now that you guys are separated? I always apply that type of logic. But there is no rule specifically stipulating that a child of 2 years old, 3 years old, 4 years old, 5 years old, or 6 years old, then they can only have specific overnight contact with the other parent. There is no rule. But obviously you have to be reasonable and looking at the child's best interest, considering a lot of stuff. If the child was never overnighted by the other parent, then obviously that must be considered. Then you must probably have to just wean it in. Regarding the question having adequate accommodation, some people are wealthy, some people are not wealthy. Some people, they live 4 people in a room. Some people live 2 people in a room, 5 people in a room. I'm not here to judge anybody. Everybody's circumstances are different. As long as the child won't be neglected and not exposed to anything bad, if there is not a bed and the child must sleep on the floor and this is the people's standard of living, that is it. Life goes on. Not everybody can afford to have a big mansion or a house with a spare room for the child to come visit every day. But if the child is sleeping with 2 adults and we might be exposed to something not good for him or her, then obviously that's not in the child's best interest. Or should the child not live with somebody that's a bit naughty, for example, like a drug addict or somebody that's very drunk, and that will be the specific room where the child will be staying in, and the child will be exposed to some bad things, that would not be in the child's best interest. But it's not a requirement that the child should have a bed and so on in order for the parent to have contact with the child. Sleeping on the floor comfortably, that is also fine. We got 3 more questions. Okay. We are currently separated since 16 July 2020, so that's a few months ago. Ever since school started again, I am only allowed to see my daughter every second weekend if I ask to have my daughter to sleep over by me. During the July-August period, when school was closed, I saw my daughter for a maximum of 5 days at a time, but my wife had her up to 8 days at a time. Me not wanting to jeopardize the little visitation I get from my wife, chose rather to not argue. I am contributing financially every month and also buy whatever my daughter needs when she is by me, example, clothes, etc. There's no question over here, but I can presume what the problem is. The problem is the parties were together, they are married, but they separated since 16th of July 2020. And now they have a problem regarding how to share this child. And that's a problem because, it was lockdown and the child was with them all the time, for the last 6-7 months. And now all of a sudden they separated, and now the mother believes she's entitled to have the child 8 days at a time, and the father believes he's entitled to have the child also half the time the mother has. This is a perfect situation where the parties will have to enter into a parenting plan. They need to sit down with a professional. They need to sit down with a social worker, whoever the case may be, to assist them. If they cannot come to an agreement regarding this, I advise the father to approach the court. And the case will be solely based upon, historically, that the child was cared by them both for the last 6 months during lockdown, and now they're separated. So his case is actually a bit stronger now based upon lockdown. Second last question, if you have been advised by a therapist that you have a right to approach a court of law to stop the other parent's contact with the child due to child negligence, what is the process? If you were advised and there's a professional document in place and the other parent is adamant they want to have contact with the child, I would advise you to urgently approach the court, children's court or a high court, and have an order put in place dealing with a specific situation. You see, it's difficult to answer these questions in isolation. Doesn't mean that there's an allegation from a therapist or his or her opinion that contact should stop, but is that in a child's best interest for contact to stop completely? Wouldn't supervised contact be possible? Wouldn't contact, limited contact be possible? So that needs to be looked at. So if you are approaching the court, come with a situation, come with a solution on how we can still have a relationship between the father and the child, if that is the case, or the mother and the child, as opposed to this stay in contact. So approach a court would be the best thing to do. And the last question, what steps or advice would you give when child maintenance is not being received? Can the parent who needs to pay child maintenance approach the court for reduction in amount immediately after divorce and before payment of maintenance has even commenced? Now, this is the problem we have. Usually these clauses regarding child maintenance are stipulated in divorce orders where the parties quickly signed it. They signed this documentation for the sake of getting divorced. But what happens is, after they divorce, they're no longer married, we have a problem of a divorce order being either, a maintenance order either being excessive, etc. If you cannot afford it, you are welcome to approach a maintenance court, but you have to convince the court or explain to the court why you have agreed to it a month or two before, and all of a sudden, now you can't afford it. If it's COVID-19, because you lost your job, that is a valid reason. However, you'll have to pass that hurdle. Ladies and gentlemen, thank you very much for your time. If you enjoy this video, please share it. Please feel free to visit our website, www.ourlawyer.co.za. There are many articles dealing specifically with these issues concerning child custody, child maintenance, guardianship rights, relocation, etc. Written for the layperson. As I mentioned earlier on, our policy is strictly, we don't focus too much on the law and this copy and pasting the law. Our policy and our way of working is to explain the law to you, applicable to your specific situation. So when you leave our consultation or obtain our advice or read our articles, you will be in a better position than you were before that, as opposed to just reading a lot of things, not understanding it, and in no better position. Thank you very much for your time. I hope you have a wonderful weekend, and I hope to see you at the next webinar. Thank you. Bye-bye.
Good morning. My name is Mohammed Abduroaf, and today's short video will deal with the issue concerning fast and quick divorces. How does it work? The reason for me choosing this topic for today is that we are getting a lot of inquiries regarding divorces. People ask us about, how long will it take to get divorced, what are the costs for divorce, etc. And there are various questions we will generally ask the client, who should they be inquiring regarding divorces. There's also some data out there that due to the lockdown, there has been an increase in the amount of people that wishes to get divorced. I do not know anything about that data, but anyway, the topic will deal with a specific issue. So if your marriage has broken down irretrievably, in the sense of your marriage cannot be saved, you try counseling, you tried whatever possible means there are to save your marriage so that you can continue being married, but there's no way. Your marriage is doomed to end, and the longer you try to keep a marriage together, more chaos arises. So you made a decision that your marriage has to come to an end, your marriage cannot be saved. Now the question is, can you get divorced, and how long does it take? If you are watching this video live, please share it. Somebody might find it useful. And furthermore, if you're watching it later on, please share it. Somebody else might have a legal problem, especially regarding divorces, and they might be informed about the specific topic. So quickly, you cannot get divorced if you are happily married. A requirement for a divorce is that your marriage has broken down and it cannot be saved. That's a legal requirement. There are obviously other aspects that has to be looked at as well, regarding minor children, property, and so on, but I will not deal with that at the specific video. There will be a webinar specifically dealing with unopposed divorces in the coming weeks. So the long and short of it is that if a marriage has broken down irretrievably, it is possible to have a quick divorce. I'll just give a short disclaimer. With regard to the COVID-19 and the lockdowns, the courts are a bit different in the approach in putting matters on the roll. So a quick divorce might not be as quick during the lockdown period. It might take a week or two longer than usual. So how do you do it? You and your spouse has to come to an agreement regarding the breakdown of the marriage. So you have to both be in agreement that the marriage has broken down and the marriage cannot be saved. That's step number one. Then you and your spouse will have to agree that the divorce will take place in an unopposed basis. Meaning one party will go to court, start a legal process, and the other party will decide not to defend it and just abide by that. If that is a principle that has been agreed upon, your divorce can proceed with in an unopposed basis. Then there are various issues that need to be resolved, as I mentioned earlier on, the issue regarding child custody. If you agree that your marriage has broken down, but there is still a dispute regarding the issue concerning where the child should reside, either with the mother or the father, then the divorce can't be quick. It will take long because you have to litigate on that issue. You'll have to argue, you'll have to convince the magistrate or the judge that whatever you believe is in the child's best interest must be applied. So that needs to be resolved. So you can't have a quick and unopposed divorce if you guys cannot come to an agreement regarding that. And the same goes with child maintenance. If the parties cannot come to an agreement regarding how much child maintenance should be paid, the divorce will not necessarily be quick. It is possible that you guys can come to some type of a token agreement regarding child maintenance, stipulating that in the interim, I will pay you X amount of money, but you reserve the right to approach the maintenance court in the near future to deal with this aspect regarding child maintenance. You do not want to block the court's role with child maintenance issues if the maintenance court would best deal with that. The divorce court needs to deal with divorce matters. And if the matter is heard in the High Court, they've got more important things to deal with than a maintenance inquiry. So that's an important aspect that needs to be resolved before a divorce can be quick and simplified. Then there's the issue concerning the propriety aspects of the marriage. For example, what happens to the furniture in the house, what happens to the pots and pans, etc. Now, if the parties are married in community of property, they have to basically share in the joint estate. So all debt, assets, whatever the joint estate has needs to be divided equally between the parties. I will not deal much with that, but that is not really an issue that can be argued. If you are married in community of property, that is what must happen. If you are married out of community of property, basically meaning What belongs to you, belongs to you. What belongs to the other spouse, belongs to the other spouse. With two possible things, with the inclusion of the accrual regime, meaning you share in the profits of the marriage, or the exclusion of the accrual regime, a total out of common property regime. So if you are married out of common property with the inclusion of the accrual regime, there are certain calculations that have to take place at the end of the marriage, and then the one party whose estate has grown will have to pay the other party half the difference. And if you are married out of committed property without the inclusion of the accrual regime, automatically there's nothing to debate, nothing to argue on. Whatever belongs to you, your debt, etc., goes with you, and the same with the other spouse. So you have agreed upon all these things. You go to a lawyer. You can do it yourself if you wish. You take them out to the court. You most probably enter the settlement agreement before the time. The court will see that you have agreed upon all these issues, or the matter becomes undefended, where you do not defend the matter because you are happy what is stipulated in the court documentation, and the divorce will go ahead unopposed or undefended. So the procedure is very simplistic. If I may just give you a typical example of how a lawyer will do it, he will meet with both parties, the husband and the wife. They will draft a consent paper or a settlement agreement attached there to a parenting plan, outlining various aspects regarding the propriety aspects. For argument's sake, they might want to agree that you keep this car, I keep that car. They might want to come to an agreement regarding the pension fund, etc. That is all stipulated in the legal document. They'll obviously come to an agreement regarding child custody and child maintenance and so on. Well-drafted document outlining everything going forward. That will be attached to a summons. The summons will be served upon one of the parties, depending upon who wants to be plaintiff, who wants to be defendant. The sheriff of the court will serve it upon him or her. The party that's a defendant that's being served will decide to do nothing. 10 days will elapse. And then the party who is a plaintiff that started the divorce proceedings will have to apply, or his attorney will have to apply to court for a court date. If there are minor children involved, the settlement agreement will be sent to the Office of the Family Advocate to be endorsed. But then on the court date, the court will look at a settlement agreement. If it needs to be endorsed, wonderful, the court will consider that, have to consider that. And if there are no issues involved on the specific day, the court will grant a decree of divorce. Best case scenario, I would say, best case scenario, 3 weeks. Under normal circumstances, average scenario was probably 5 weeks to get divorced very quickly. It will always also depend upon the court, whether or not it's in a high court or in a magistrate's court. Some courts are very busy. Some courts only deal with divorces on certain days, etc. But the long and the short of it is, a divorce can be very fast and very quick if both parties agree to the terms of the divorce. I hope you found this video useful, and please, we're looking forward that you join us in our future videos. We will be having a webinar, as I mentioned earlier on specifically regarding unopposed divorces, where parties can pose questions and we will try our best to answer them. Thank you very much.